Okay, can you see the slides up there now?
Yep, we can see the slides. Welcome, everyone. We'll be getting started here in just a minute. Okay, I guess we'll get started now. A few more people might be hopping on, but welcome to Northwest Regional Planning Commission's Essentials of Land Use Planning and Regulation workshop. My name is Greta Brunswick. I'm a senior planner here, and I also have we also have Emily Kloft, a regional planner, here with us tonight. And this is a training that we offer a few times a year for folks that serve on planning commissions, development review boards, other municipal committees, the select board, but primarily focusing on those involved with land use planning. It's a primer on the essentials of Vermont land use planning and regulations. And it is great for those that are new to this. And it's also great for those that just need a refresher and perhaps are more experienced. We're going to start off tonight with two sections on planning, focusing on planning for a vibrant, sustainable community, and then roles and responsibilities in planning. And then we'll close the session with plan implementation and meetings, hearings, and due process. We will keep it open for, we'll prompt questions, but I will try to address questions as needed periodically through the presentation. But if you could hold them to primarily to when they're prompted, I think that might keep things organized. And I guess, let's see. I am curious to know of the folks that we have here tonight, how many, and maybe we can just show, maybe Emily, can you not share your screen just for a second? There we go, so we can see everyone. I know some of your faces tonight, but do we have, who is a planning commissioner? Maybe you can just raise your hand. Some of you don't have your, okay, so we have a few planning commissioners tonight. What about development review board members? Some of those as well. And let's see, yeah, we're looking for participation tonight. Yeah, so you'd always use the thumbs up feature within Zoom, as Jessica did as well. So some DRB members, some planning commission members. Anyone else? Anyone on a different type of board in their community? Primarily just, okay, great. Just curious. We have a nice mix there tonight.
Hi, I'm Sam Lasham from the Central Vermont Regional Planning Commission.
Oh, awesome. Hi, Sam. Welcome.
I'm Brian Boyd. I'm also from the Central Vermont Regional Planning Commission. Sam and I are both relatively new hires there.
Okay, great. Welcome. Okay, well, I think that we can, we do have a small enough. Why don't we go around and introduce everyone else? Sandy, why don't you go ahead and give it a start?
Hi, I'm Sandy Gregg, and I'm on the Planning Commission in South Hero.
Great. And George?
I'm a new planning commissioner in North Hero.
Okay, great. Welcome. Hannah's next on my screen.
Hi, I'm planning commissioner in St. Albans town.
Okay. And Jolie's next on my screen.
Hi, I'm a planning commissioner for Fairfax.
And Kevin is next on my screen.
Hey, everybody, I'm Kevin. I'm a planning commissioner from Fairfax as well.
And Jessica, oh, having connection issues, Select Board and DRB in Enosburg. Welcome. And then Alec is next on my screen.
Yeah, hi, I'm with Lamoille County Planning Commission.
Okay, hi. And Sal.
Oh, can you hear me?
Yeah.
Yeah, sorry, I'm having our webcam issues, but I am also with Lamoille County Planning.
Okay, wow, we've got a lot of regional planning commissioners here tonight. Or great, welcome. So we will get started now. I'm going to turn it over to Emily Cloft, and she's going to share her screen for the first part of the presentation.
Great. Let me get a minute here to just get my share screen back up. All right, great. So the first section will be talking a bit about planning for a vibrant and sustainable community. So as we look at this image by Grandma Moses, the question is vibrant and sustainable. What does it mean to you? So if anyone wants to give their answer or put it in the chat. Quiet group. All right. If you have some thoughts, you can put them in the chat. So really, when we think about a vibrant and sustainable community, what does that mean? What type of community do you want? And how can land use regulations and planning help you get there? So this is how Grandma Moses envisioned a vibrant community in the early 1900s. And since then, we've developed tools and laws that sort of codify these common community goals. So Vermont has been planning since basically the 1920s. And Chapter 117, which is where our land use regulations live in statute now, was established in 1968. And this defined planning more as we know it today. There's been two really major overhauls of this. In 1988, there was a major overhaul focused on planning, including adding the state planning goals and the required planning elements. And then there was changes in 2004 that focused more on zoning, on process and affordable housing. At that time, communities had until 2011 to make sure their bylaws complied. And then most recently, there have been changes with a focus on affordable housing, such as regulations around ADUs, small multi-unit dwellings, and allowing development on small lots. So what is a municipal plan? They are guides for accomplishing the community aspirations and intentions through public investments, land use regulations, and actions the town can take its vision. And why would you want to have them? Municipal plans really help municipalities determine how different areas of the town can be planned as a single unit and meet the goals of the community to develop it, and developing a community-wide vision. Development can be planned by anyone in the community, whether that's individuals, businesses, the town, or a combination of all of these. But no one just starts a construction project by nailing boards together. So it's really important to have a plan to consider how you want your community to grow and help guide future development. There are also a number of more concrete benefits of having a municipal plan, including being allowed to adopt zoning, subdivision, and flood hazard regulations. If you are a community without a municipal plan, you can adopt flood regulations by ordinance. Act 250 applications have to conform to your town plan, so that's the state's development law. And your town plan will also be considered in Section 248 Certificate of Public Good applications. And those are the renewable and telecommunication projects state permitting structure. And also you are more eligible for competitive for many grant applications. For example, you are eligible for Vermont Community Development Program funds. So this slide reviews in more depth the planning process. So you'll see that step 1 through 5 here are kind of what happens when you're going through a plan update. So assessing the community, developing a shared vision, identifying the community goals and objectives, mapping out the future, and identifying priority action items. And then in orange here are implementation and review, which is sort of what happens in between each time that you're updating your plan. So you're ideally looking at your implementation table and implementing that, and then reviewing your plan over time, knowing that it's a living document, which where there's information, community circumstances, and goals are changing. Once adopted, it's a really good practice to conduct an annual review of your implementation strategies and determine what steps you can take in the coming year to try to work on those. And review of the plan is also really important as it comes towards the time for your plan to be revised. So what are the goals as you engage on the planning process around your municipal plan? Well, really, it's about working together towards a common vision and getting input from everyone in the community, including and other boards in the community, as well as neighboring towns. So it needs to be a coordinated process with citizens' participation at all levels that considers the use of resources and consequences of growth, and that also works with neighboring municipalities and regions to implement plan. So as this quote states, when it comes to planning, if you're not doing it with people, they think you are doing it to them. So people will generally resist change if they haven't been involved in the process of planning. Because of that, it's really important to have citizen participation in your planning. There are lots of different types of citizen outreach, and you should be using a combination of these types to reach different people, and because they have different goals. So for instance, if your main goal is to just inform residents about a planning process that's happening, then you might use something like Front Porch Forum or your town website or a local newspaper. If you're looking for some feedback on an already existing plan or idea you have, you might want to consult them through something like a survey. If you are looking for new ideas and dialogue, you might want to involve them, for example, through a focus group. And finally, if you really want a collaborative process where they're generating new ideas and then you're bringing those into outcomes, you might do something more involved like a charrette. It's really important to determine what your goal is for the outreach and then try to match the type of outreach to what information you need to get. And NRPC can help when you're looking at what type of outreach you want to do for a plan. So how do you engage people in planning? Well, one of the biggest things is to talk to people, especially in small towns. Oftentimes the best approach is just to talk directly to people who might be interested or affected by planning processes. This also really helps alleviate fears and helps communicate respect to people. And it's also really great if you know there are people in your town that are well connected. By providing accurate information directly to them, then that makes sure that accurate information about your plan is in the community as a whole. It's also really important to meet people where they're at. So most people are not going to be super excited about the idea of coming to like a planning commission meeting on 6 p.m. So they're much more likely to find new people that are interested in hearing about your plan and want to give involvement if you meet them where they're at, like a senior center or a school or another community space. You can also make your public engagements fun by adding food, for example, having a potluck or competitions like a photography competition for your town plan. And then finally, just encouraging a culture of communication in your town in general. The planning works best when the communications between government, boards, staff, commissions, and the general public is open and free. So using tools like your town website or Front Porch Forum to inform people about town business, and having places in town where people can gather and talk, holding things like walk and talk sessions where people can walk around the community and talk about a specific issue, as well as creating short-term advisory committees when there are issues that need to be addressed, but people might not want to commit to being on a long-term board. So now we're going to get into a bit more talking about what should be or could be in your plan. So Vermont has 14 state planning goals. that are sort of interlocking around this theme of creating a vibrant, sustainable community. So things like having available childcare, recreational opportunities, flood resiliency, and natural resources, along with many others that you can see on this chart. And we'll send this out after for everyone's. Everyone don't have to take notes if you don't want to. All connect to this goal of creating a vibrant, sustainable community. So town plans may be consistent with these planning goals, but if you want regional approval, and we'll talk a little bit more about what that means later, you shall be consistent with these planning goals. And your plan being consistent with these planning goals means that your plan can't conflict with the goals, and you need to be making substantial progress towards attainment. So all municipal plans, regardless of whether they're looking for regional approval or not, do need to meet these 12 requirements of areas to address: objectives, policies and programs, land use, transportation, utilities and facilities, education, energy, economic development, housing, flood resiliency, policies on preserving rare natural areas, compatibility with adjacent municipalities in the region, and the implementation program. So these are required for all plans, but you can make it your own. You don't have to structure your plan this way. You just need to make sure they're all addressed. With all these requirements, it can be really easy to get caught up of creating a plan that sort of just documents all of the existing conditions in your town. But it's really important that your plan go beyond that and focus on creating a shared vision for the future of your community. So what is the adoption process like for municipal plans? So for those of you who may have been seen this presentation or know a little bit about municipal plans, you may note that municipal plans used to expire every 5 years, but from now on, any active plan that is being adopted is going to last for 8 years. You'll want to start revising or rewriting the plan before expiration. What a revision looks like can really depend on your community's resources and capacity, but at minimum, you should be making necessary edits to data and implementation program every 8 years. The adoption process can take several months. It starts with a planning commission hearing that involves also noticing adjacent communities. Then you'll have 1 to 2 select board hearings depending on the size of your community. So you need 1 select board hearing if you're a rural community, which is 2,500 people or less, and 2 if you're an urban municipality, which is more than 2,500 people. And then the decision on the town plan, on the municipal plan, will have to be made by the legislative body. So that's your select board, village trustees, or city council, unless the legislative body or the voters have decided to vote on the plan via Australian ballot. So in some communities, the town plan is voted on via ballot. And then once adopted, the plan immediately goes into effect. So if you're seeking regional approval and confirmation, it allows you to access additional benefits of your town plan if you have an approved town plan and your planning process has been confirmed by the Regional Planning Commission. For those in Franklin and Grand Isle County, that's Northwest Regional Planning. So a municipal plan is considered approved by the Regional Planning Commission if the plan is consistent with the statewide planning goals, if it's compatible with the regional plan and the plans of other municipalities in the region, and it contains those required plan elements. So the RPCs, we meet with member municipalities once every 4 years to understand a town's need and determine if any assistance is needed. This is when relates also to the confirming of the municipal planning process. So separate from your plan being approved, you will have a confirmed municipal planning process. If you have a approved plan, your municipality is engaged in a process to implement the plan, and the municipality is maintaining efforts to provide some funding for planning. With that confirmed planning process, your municipality can apply for a state designation such as a downtown, village center, new town center, neighborhood development area, or growth center designation. You can apply for municipal planning grants. You can have impact fees, and you also can have your plan considered by state agencies in their planning efforts. I'll also note here that there is a separate approval process for enhanced energy plans developed by municipalities. which allows for greater deference during the Public Utility Commission Section 248 hearings. These requirements are very specific, and you should work with NRPC if you are adopting an enhanced energy plan to make sure that it will be approved. So finally in this section, this is the link to the Vermont Planning Manual, which is a really great resource with a ton more in-depth information on developing and planning for your municipal plan. And if you are looking at a municipal plan process, this is a great place to look. So I can pause here for a moment if there are any questions on this section. All right, I'm not seeing any, so I will move on to section 2, which is roles and responsibilities. So the roles and responsibilities in the municipal level, so in some ways reflect similarly to the roles and responsibilities that you see at the federal level, where we all learned in school about the 3 arms of the US government, where you have the legislative, which is Congress that writes the regulations, the judicial, which in the federal context is the Supreme Court, which interprets the regulations, and the administrative, which is the executive branch, which administers and interprets regulations in a non-discretionary way. So at the local level, this chart can look something like this. So at the top here, you have the legislative body, which can be a select board, city council, or village trustees, depending on what type of municipality you are. And legislative functions in municipalities are typically split between the planning commissions and the select boards. Then you have the quasi-judicial role, which can be either a development review board, or some of our municipalities still have a zoning board of adjustments and planning commission that are involved in that. And finally, you have your administrative role, where you have your zoning administrator, at least in terms of land use here, interpreting the regulations in a non-discretionary way. So to go into some more detail about that, so the Planning Commission occupies a legislative function when they prepare the municipal plan or zoning regulations, or they can prepare, edit capital budget or programs, or prepare other studies. The legislative body also has a legislative role when they review, edit, and approve or send to the voters the municipal plan or zoning regulations, and when they prepare or adopt a capital budget or program. So in terms of this quasi-judicial function, municipalities usually have either a development review board, which reviews site plans, subdivisions, conditional uses, lots without frontage, variances, or appeals of ZA decisions, or some municipalities have a split planning commission, zoning board of adjustment model, where the planning commission reviews site plans, subdivisions, and lots without frontage, and the zoning boards of adjustment deals with conditional uses, variances, and appeals of the ZA decisions. The DRB model is generally more simple. It simplifies the roles of the board in the process for applicants, rather than needing to go for 2 boards. If they're, for example, many applicants might need to have both conditional use and site plan approval, for example. And it also allows the planning commission to solely focus on their planning functions. And membership can overlap between a planning commission and a development review board. So if someone is interested in both of those functions, it still allows them to maintain that. So for that reason, the development review board model can be more beneficial. And then finally, at the administrative level for land use planning, you have the zoning administrator, whose job it is to issue permits for zoning regulations that have been already determined can be approved administratively, as long as the proposed development or activity is in conformance with the required density, dimensions, and uses prescribed in the regulation. Zoning administrators are also responsible for enforcing the permits and ensuring that building isn't occurring without permits. And depending on the town, ZAs often have other functions or duties. In many towns, ZAs also staff the DRB, PC, or ZBA. And then finally, a note on some of these terms that you might see: regulation, bylaw, and ordinance. In the Vermont statutes, bylaw specifically refers to zoning, subdivision, and other land use regulations adopted in conformance with the municipal plan, while the word ordinance is used to refer to regulations adopted directly by the select board and other municipal legislative bodies, for example, public works standards or noise ordinances. And the word regulation is used as an umbrella term to refer to all types of governmental rules. Some differences between bylaws and ordinances in Vermont are that bylaws allow for pre-existing nonconformities. So if you have an existing use that is not in conformance with the bylaws, it can continue. In contrast, an ordinance is effective immediately regardless of prior use. And bylaws and ordinances also have separate adoption processes that are outlined in statute. And that is the end of the rules section. So I'm going to leave another moment for any questions that might have come up. Okay, I see Jessica says, can you give an overview of the regional role with municipalities, i.e. DRB? So in terms of how we interact with those, or I'm not quite sure. Technical support, yeah, so we can provide, NRPC will provide, we can answer technical assistance questions from zoning administrators as they come up, or from DRBs. To a certain extent. So that tends to be our main roles. We can help provide that, and we can help, we often work with municipalities on updating their bylaws on the planning commission side. And with that, we're often trying to create regulations that are easier for DRBs to follow.
And I guess the only thing I would add there is, this is something that we can qualify at the beginning of these presentations, is that we are not qualified to give legal advice. And so that goes for any of the advice or technical assistance that we provide to zoning administrators or development review boards too. So it goes without saying.
Yeah.
Great. Was there any other questions on the first two sections? I'm just gonna share my screen here, or just give me a moment here while my section of the plan up, or presentation up. There we go. Are we all set now?
Oh, look, there we go. Yep, there we are.
Okay. So we are now starting section 3 on moving on from now. You've adopted your plan. You have a great vision for your community, and you're ready to start putting that plan into action and realizing that vision. So we're going to talk about implementing the municipal plan. So the intent of making a plan is to realize the goals and aspirations it contains. There's many ways to go about doing this, and we generally can categorize them into two different types: regulatory implementation and non-regulatory implementation. So we have zoning bylaws, flood hazard bylaws, and local ordinances on the regulatory side, and a whole variety of different non-regulatory tools that can also work towards achieving the vision in your in your town plan. As of 2016, municipalities now must document that it is actively engaged in a planning process to implement its plan as a part of the regional confirmation process. So that is something that is important to keep in mind. So why have local land use regulations? Exploring the ins and outs of the regulatory side. Really, in a nutshell, regulations are a very effective way of furthering the plans, the vision and goals in your town plan. So to implement the vision and goals in your municipal plan, there are a variety of different goals that can be achieved. So we have promote So for example, promoting compact and walkable development, protecting important natural resources, minimizing fragmentation of farmland, incentivizing affordable housing, encouraging efficient use of infrastructure, ensuring compatibility with historic character. These are all great goals that might be included in your town plan. So how would these be furthered in your local regulation? As an example, a goal for promoting compact development can be furthered by implementing regulations that ensure that buildings and driveways and streets support that desired pattern of development. Taking a look at natural resource protection and farmland fragmentation. That goal could be furthered by minimizing new development in those resource areas, such as by limiting the layout and length of new roads and driveways, or supporting the kind of uses that are compatible with maintaining farms and forests and large parcels of land. So those are just a few examples of how those goals could be translated into regulations that would have the impact of furthering them. It's also worth noting that in Vermont, more projects are subject to Act 250 review if the community does not have zoning and subdivision regulations. So it determines whether commercial development triggers Act 250 review based on whether at 1 acre or 10 acres, and whether a subdivision triggers Act 250 with 6 lots or versus 10 lots. So there are some limits to local regulation. So first, land use regulations can tell people what they can and cannot do with their land, but they cannot deprive landowners of all reasonable use of their property without just compensation, which would be considered a government taking. And so that's documented in the 5th and 14th Amendments of our Constitution. The 5th and 14th constitutional amendments limit a municipality's authority, while subsequent court cases, I think there's over 20, I'm sure there's many, or at least over 25, have clarified what all reasonable use of property means. One important test the court applies is whether a law denies a property owner all economically viable use of land. Amongst many questions, the courts have also considered the extent that the use of property is limited without effect of the law under question, and the extent that the law will fall under a governing body's police power to protect public health and safety. So we have the opportunity here in Vermont to see how a takings case rolls out. Perhaps you have seen the newspaper articles in Vermont Digger as of late, but a developer is currently suing the town of South Burlington, claiming that it is taking their property based on a zoning amendment. So that's going to be interesting to see and how that pans out, and every single new court case relating to this is important to really understand how local zoning can apply in terms of landowners' rights and the ability for governments to regulate land. So, and then second, Vermont is considered a Dillon's rule state as opposed to a home rule state. And this means that municipalities can only regulate what is specifically enabled by Vermont statute. So we have Title 24, Chapter 117, the Vermont Planning and Land Use Regulation Act. And that sets forth the authority for Vermont, for municipalities to regulate land development. And so within that act, municipalities are given specific authority on what type of regulation they can have. And if that is not outlined in that statute, then municipalities are not able to do that type of regulation. And so third, Vermont statute places specific limitations on local regulations. So this is primarily in section 44, 12, and 13 of the act. But those limitations touch on, for example, treating housing types equal and avoiding discrimination against affordable housing, including accessory dwelling units and multi-unit dwellings, protecting home occupations and home daycares, ensuring the continuation of nonconformities and that small lots may be developed, ensuring lots without frontage may be developed with adequate access. The regulation of public facilities shall not interfere with the intended functional use of those facilities, and that no regulation of accepted agricultural practices and silvicultural practices, and also applications requiring a certificate of public good, as Emily noted before as well. So there are some limitations. We're given broad authority to do regulation to the extent that it will further the goals in our town plan, but within the confines of these limitations. So this slide shows the flow of a local zoning application and who's involved in review. So we start with the zoning administrator receiving an application. The zoning administrator is really the face of the permitting system and development review system for the municipality. In some larger municipalities, there may be several staff, but in most of the municipalities in our region anyway, there is a single zoning administrator, maybe with an assistant. And so that zone administrator receives the application. And then there are two paths for that permit application. One path is administrative review, and the other path is a quasi-judicial review. And so projects that are simply a permitted use and do not require any quasi-judicial review from the DRB or the Planning Commission would simply be reviewed by the zoning administrator, and the zoning administrator would issue or deny that permit. And then once issued or denied, there would be the opportunity for appeal. If the particular application requires conditional use review, site plan review, or subdivision review, the zoning administrator is going to be referring that application to that appropriate board, in most cases, the development review board, who's then going to conduct that review and hold a public hearing. And following the closure of the public hearing, is going to deliberate and eventually issue a written decision. And then there will also be an opportunity for appealing that decision once that decision has been issued. And it's important to note that here we do have a recommended practice, and this is a common practice, I think, in a lot of municipalities for the for the ZA to issue a permit when all board approvals have been attained. So there is, a final ZA action at the end when there may be multiple approvals that might need to be obtained. That final zoning permit is what would then ensure that that landowner knew that they could move forward with their project. So moving on now to local regulation and the different types of review that are enabled. We talked about being a Dillon's Rule state, and so in the Act, the Planning and Development Act, there are many different types of zoning regulation that municipalities can enact. So I think it's important first to start with the definition of land development. And so this is a definition that is included within statute. And so this is what zoning can regulate in a nutshell. So we have that definition being a division of a parcel into two or more parcels, construction, reconstruction, conversion, structural alteration, relocation, or enlargement of any building or other structure, or of any mining, excavation, or landfill, and any change in the use of any building or other structure or land or extension of use of land. So that sets the parameters of land development and what zoning can apply to. And then beyond that, there are different types of standards and review processes that the town can adopt to regulate land development. So to begin with, we have permitted uses, which are permitted administratively and require a permit with limited administrative review. Then we have a conditional, although I want to say, I guess I'm going to add on to that, is that in the age of form-based codes, where there is the ability to add additional prescriptive standards to your regulations so that more complicated types of land development could be administratively permitted by the zoning administrator. So I'm going to make that qualification there. Typically, a permitted use is something that has a simple review, although we are looking at, there is more of a trend as we're looking at form-based development and making a predictable process for land development, that additional, more complicated land use with the right standards can be permitted as well. And so then we have conditional use review, which considers the external impacts of use and compatibility of the surrounding land uses. So the use may or may not be appropriate, and it's going to be a deliberative, subjective decision of that board to apply the standards and make that determination. We have site plan review, which considers the internal impacts of use by looking at the design of the specific parcel. So this is not an issue of whether the use may or may not be compatible with the neighborhood. This is more of let's ensure that the internal design is going to work well. And then we have variances, which allow for the relaxation of dimensional standards for structures in very specific uncontrollable circumstances. And so variances are not easily obtained if you're following the true 5 statutory criteria in the statute. So variances need to be created by a physical situation on the lot. It needs to be the minimum variance that could be built. It needs to not be created by the applicant. And it needs to be necessary for reasonable use of the property. So those are some of the very strict criteria that are needed to be met in order for a variance to be issued. Statute also provides for waivers. Waivers allow for the relaxation of specifically defined rules so long as there's a clearly defined process and standards for how the waiver will be applied. So this is a situation where municipalities might define, it's not encumbered by the strict statutory standards for variances. And so an example of where this could be appropriate would be for handicapped or historic structures that within a certain village district. So there could be, whether it's a handicap ramp or porch or something that might afflict a historic structure within a village district. That might be a situation where a municipality would craft specific waiver standards where those types of improvements could encroach in a setback area. And then planned unit development. This type of review, it allows for a flexible development plan for a specific project. Some rules may be modified. So some of the zoning standards could potentially be modified as a carrot for implementing good design. And so the intention is that there are certain design standards that are met, and in exchange, there's some additional flexibility in meeting those zoning standards. Usually this is in the form of additional density, but there's, it can be crafted by the municipality. This is most commonly also known as a conservation subdivision in a rural area where where a smaller lot sizes might be allowed if they're clustered, so that the balance of that land then remains open and is either preserved for farming or recreation or other open space. And then, I went a little bit, finally, the subdivision there at the bottom of the page controls the pattern of future development. And so there's a subdivision review enabled by statute as well. Any questions at this juncture? Okay. So moving on, you have developed your bylaws. You've defined your zoning districts and the standards that you're going to use to regulate development within those districts. I'm going to move on and talk a little bit more about the review process. So all reviews conducted by quasi-judicial boards must result in a written decision. And these decisions must contain findings of fact on which each decision is based and conclusions of law on how the bylaw applies. They must be based on review standards in the bylaw. Minutes may suffice. The law does allow for that, but that I think it's best practice, and your decision is likely to be more defensible if you craft a separate written decision that specifically calls out the findings of fact, includes conclusions of law, and is not minutes. But just so you know, minutes do suffice. The decision should be memorialized by concurrence of the majority of the board. The timeline for issuing decision is 45 days. So at the close of the hearing, a DRB has 45 days before they are required to issue that decision. I think this is really important for development review boards to understand. There is absolutely no need to make a decision the same night as the final public hearing. The board has 45 days to take time to really consider all of the testimony that was issued or that was presented at the hearing, and carefully craft a written decision that outlines all of the findings of fact that were heard, and to really craft the conclusions of law that are the basis for that decision. That is the best way to ensure that the decision is going to be legally defensible, to set the municipality up right for a good decision. So in many communities, volunteers end up being responsible for preparing a decision. It's a big job. I think that it can be helpful, very helpful, to have staff that is able to assist our volunteers with preparing those decisions. But in many cases, it is volunteers. You know, there are resources available to help craft decisions to ensure that they're written well and are legally defensible. One thing that's important to note is decisions should memorialize a concurrence of the majority in making that decision, but it should indicate how the vote turned out. So we want to ensure that, you know, it was 5-4, you know, a majority voted in favor, but it does not need to include the names of who voted, and it does not need to be signed. And I'm going to get into this more, but that deliberative session is not subject to the open meeting law. So it happens after that public hearing is closed, and it can happen as needed by those board members. And so that final decision is what memorializes that decision. So now moving on to appeals. The applicant and interested party always have the ability to appeal an act or decision of the ZA and any decision of a quasi-judicial board. So appeals are either at the local or state level. So a decision of the administrative officer, the ZA, is appealed to the DRB. A decision of the DRB is appealed to the Superior Environmental Division of the Superior Court. We used to call this the Environmental Court, but there was a slight change in that. It's really the Environmental Division of the Superior Court. So the Superior Court Environmental Division hears cases de novo. So unless the municipality has adopted the Municipal Administrative Procedures Act. So de novo means that they're not taking into account any of the testimony that was presented in the local proceeding. They're going to start fresh. So in our region, Montgomery is the only town that has adopted the Municipal Administrative Procedures Act. And so in doing so, they make their own interested party determinations, and their appeals do take into account that testimony that was heard at the local level. It's not a de novo case at the appeal. So that's just something to note. In our region, it's only Montgomery. I'm not sure about other regions around us like Lamoille or Central Vermont. One other thing to note is that when local decisions are appealed to the Environmental Court, Superior Court Environmental Division, the municipality does not have to defend the decision or put in appearance, although it can, and it may make sense to really participate in an appeal of, you know, something that a decision relating to your zoning bylaws, but it's not required. So interested persons are eligible to make appeals. So you can only appeal a local regulatory decision if you are an interested person. And so Vermont statute defines an interested person as the applicant, the municipality and any adjoining municipality, property owners in the immediate neighborhood of the subject proposal, any petition of 10 persons or combination of voters and property owners, any department or administrative subdivision of the state, owning property or an interest, and the Agency of Commerce and Community Development. To appeal in the e-court, you also need to have participated in at least one of the hearings to be eligible. And so written participation counts. So if you can't attend the hearing, you could submit a letter documenting what your comments are, but you do need to participate. And so as I noted before, Montgomery is, because they adopted the Municipal Administrative Procedures Act, they are required to make those interested person determinations at the local level, during their public hearing. But if you're not have not adopted MAPA, you do not have to make those determinations, and you can just let whoever wants to participate, make that note about whether they want to seek interested person status in the sign-in sheet. And then the environmental, should they appeal, the environmental court will make that determination on whether they meet that status. Oops, sorry about that. And then, so I guess that closes my presentation on the regulatory implementation. And I'm just going to touch on, really this presentation does focus more on regulatory, but there are many different ways that towns can engage in non-regulatory implementation of the town plan, such as shaping current and future town spending to make sure that the goals of the plan are achieved through a capital budget and program. And so this is something that requires close coordination with the Planning Commission and the Select Board and Trustees, because the Select Board and Trustees are really who's primarily involved in budgeting. Tax stabilization contracts, so creating favorable tax provisions to create incentives for certain land uses. The purchase of development rights, so purchasing land for conservation or public facilities. Advisory commissions, so there are many subcommittees that could be created by a planning commission to study specific issues, such as housing or economic development or village revitalization. And just as advisory commissions, you could also just focus on other projects, whether it be wastewater feasibility, village master planning, housing study. So these are all different ways that the municipality could engage in other types of planning, non-regulatory plan implementation. Some of the other advisory commissions that I didn't mention: Conservation Commission, Housing Commission. What are some of the ways that your communities are engaged in implementing the plan in a non-regulatory way? Anybody want to talk about any non-regulatory implementation that you might be doing in your community? I know we have a lot of regional planners on here, but I guess looking for.
I'm trying to remember where the latest studies are, but I know that we're working on our health path. Sorry, the sidewalks and
recreation, sidewalk planning.
Yeah.
Great.
So
okay.
Progress at least.
I'm going to reshare here, and we're going to be moving on to the last section of the presentation. This resource, the Vermont Land Use Planning Implementation Manual, is available at www.vpic.info. It includes many different, I think they're called modules, on different ways of implementing the plan, both regulatory and non-regulatory. It's great as a planning commission member if you wanted to focus some conversation on a certain type of project or effort that you could get started on. This gives a great primer on different implementation methods to talk and learn and plan for how you might want to, what you might want to work on over the next year. So definitely reference that. So now I'm going to be moving on to meetings, hearings, and due process. So This section focuses on due process, which means simply that all proceedings are conducted fairly for everyone. Due process is guaranteed by the Fifth Amendment of the US Constitution, which states no person shall be deprived of life, liberty, or property without due process of law, and is applied to all states by the 14th Amendment. So ensuring due process means that everyone is given notice of the proceeding, opportunity to be heard, that order is maintained, that evidence is managed, and that conflicts of interest are managed as well. So I'm going to start by touching on a summary of the open meeting law, which ensures that due process is protected and that we have access to our government proceedings. So the open meeting law requires all meetings of public bodies to be open to the public unless a specific exception applies, and there are a few. In order to make a meeting open to the public body must provide advance notice, notice of meetings, including meeting agendas. They must discuss all business and take all actions in the open meeting, unless an exception applies. They must allow members of the public to attend and participate in the meetings, and they must take minutes and make them available to the public. So applying the open meeting law, the meeting law applies to all public bodies. So what is a public body? A public body is any board, council, or commission of the state or one or more of its political subdivisions. So it is select boards, it is trustees, it is city councils, DRBs, planning commissions, and it is also any subcommittee that might be created by a planning commission. So any public body, you are then needing to comply with the open meeting law. And then to apply to the open meeting law, you need to be a public body, and a meeting also needs to happen. So when does a meeting happen of a public body? When primarily a quorum needs to be gathered, which is a majority. So a majority of the public body needs to gather to discuss business or take action. Then you have a meeting. So some important things to consider are that email conversations can be considered meetings. There are only certain exceptions on and when email between board members can happen, and that is to set agenda items or to distribute materials that are going to be discussed at a meeting. And certainly it is not appropriate to try to get around that by having one member email different members of the board. We call that daisy chain or serial communication, which would be trying to avoid get around that requirement. It would be a violation of the open meeting law. And then also it's possible that text, online editing, and social media could be considered meetings. So you really just need to be aware when, if a majority of members of a public body are commenting on a Facebook page and it's concerning business of that board. So whether it's concerning roads or that is a meeting and would be a violation of the open meeting law. So it is important to note that there are some temporary changes to the open meeting law. There is no physical location required anymore. Typically there is a physical location required, but until January of 2023, due to the COVID-19 pandemic emergency, there's no physical location required. You can conduct meetings entirely remotely, but you need to use two electronic places rather than, you can also post into electronic places rather than physical locations, and I'll get into posting in a minute. So meetings versus hearings. We want to talk about meetings, then we also want to talk about legislative hearings and quasi-judicial hearings. So in the planning and development world, you're going to be conducting regular meetings, and you're also, as a planning commissioner, going to be conducting legislative hearings. And as a development review board member, you're going to be conducting quasi-judicial hearings. So at meetings, you're going to be discussing business of the board and taking action, generally a legislative Act, and all public bodies do this. At a legislative hearing, this is the type of hearing that you are receiving comment on a course of action like a plan or a bylaw. So a plan or a bylaw adoption. These are the hearings that you're required to have for adoption are legislative hearings. The Planning Commission does this. The Select Board also does this when they have their hearings for adoption. And then the quasi-judicial hearings are held in like a court proceeding, and you're hearing testimony from interested parties when an applicant is seeking approval from a board. And so that is done by the Development Review Board primarily. So there are specific timelines for advance notice, depending on the type of meeting or hearing you're holding. So we have regular meetings, and each board will set a regular meeting date. If they do want to set a regular meeting date, they will do that by ordinance or resolution. And notice of that meeting must be set 48 hours in advance by posting the agenda. And the agenda must be posted at the town and 2 other places in the town and on the official website if it exists. Special meetings are if you're going to have a meeting that is not at your regular meeting time, or if you have not set a regular meeting time, that would be a special meeting. And those agendas need to be posted 24 hours in advance with the same posting requirements as regular meetings. You also are able to have emergency meetings, though generally this would be only appropriate for a select board. If there was a major fire or something along those lines where the board needed to meet and talk about that, or if there was damage from a flood or something along those lines. And notice can be provided as soon as possible. So here's where I really meant to talk about the temporary changes to the open meeting law, which are in effect until 1/23, where the agenda must include details for direct telephone and electronic participation. That is absolutely required, and there's no physical location required, and you can use 2 electronic places rather than the physical locations for posting the agenda. So we're up here where we talk about 2 other places in the town. Normally there's 2 up, like the post office or sort of a general store in addition to the town office for postings. And so under this temporary change, you can use electronic places rather than those physical places. Public notice for the legislative hearings and quasi-judicial hearings. There are additional notice requirements for these. For legislative hearings, there is a 15-day notice requirement. And I guess the only exception to that really is for the first Planning Commission hearing, there is a 30-day notice for the certified mailings to adjacent municipalities of that public hearing, in addition to sending the copy of the draft plan. The legislative hearing also needs to be posted in the newspaper of record at least 15 days in advance of the public hearing. And in that, similar to the postings for regular meetings, needs to be posted in those 3 places and on the website. For quasi-judicial hearings, the development review, we've also had 15 days notice, newspaper of record, posting in the 3 places, including the website. The notice is also mailed to abutters, so abutting property owners to where the project is located, and it also needs to be posted, physically posted within view of the nearest public right of way. Just touching on minutes quickly. So the content minutes need to be posted within 5 days and posted on the website and maintained for 1 year. So generally the draft minutes are posted on the website, and it's not a requirement that a board adopt minutes to make them final, but it's certainly a common practice. But those draft minutes do become part of the public record. So that's important to note. The content of the minutes needs to be they need to include all members in attendance, the name of active participants, motions, proposals, and resolutions, and the results of all votes. They should also characterize any major discussions that happened. I'm going to talk about here the flow of quasi-judicial hearing. So these are the Development Review Board public hearings. So rules are stricter for the quasi-judicial hearings because the board is deciding how to apply the law, and And it is important to understand that due process rights need to be protected for all interested parties involved. So, and generally this can be a new process for volunteers that are getting involved on the development review board in their community. None of us are lawyer, or you're typically not a lawyer, you're typically not a judge, you're typically not someone that's, going to court proceedings very often. So it's trying to find that balance of protecting due process rights of parties and maintaining order, but balancing that to the fact that you are still a small town. So we're going to lay out some best practices here. So this outlines a typical flow for a quasi-judicial hearing in the communities in our region. So we have the chair opening the hearing, the applicant presenting a proposal or request, board members asking questions in relation to the conformance with specific provisions in the land use regulations, time for comment from interested parties or the public, the closure of the public hearing, and at the point that the public hearing is closed, deliberations can then start happening. It's certainly okay for deliberations to happen in public, but we think it makes a lot more sense. It's certainly a better practice for a board to do private deliberations. And like I noted before, there are 45 days for those deliberations to happen before a decision needs to be issued. And so those deliberations do not need to happen that night. And then finally, the board decides on the application and issues a written decision. So there are some best practices for the chair to take when opening a quasi-judicial hearing to set the stage for a fair and orderly proceeding. So the chair should review the order of events, remind of the importance of order, make copies of the rules of procedure and ethics policies available. Rules of procedure and ethics are a requirement of all boards. So if you're not sure if your board has them, you should ask. And perhaps if you find that you don't, this is an opportunity to, as a board, adopt them and comply with that requirement, but then also just understand these rules of procedure and to ensure that you are going to be conducting yourselves in an orderly manner and in a transparent way. Review the definition of interested persons and ensure documentation of participants, and administer an oath when appropriate. And finally, to request disclosure of conflicts of interest or ex parte communications. Doing so at the beginning and making that just part of your standard business is going to ensure, or is going to make disclosure easier. And it's really a best practice to ensure that you're managing conflicts of interest and ex parte communications appropriately. So a good chair is vital for smooth, efficient, and productive meetings and hearings. The role of the board chair is to administer the agenda, keep board members focused on the issue at hand, and ensure the board finishes on time. A good chair should state the question, ask for discussion without giving their own opinion, and bring the board to resolution after discussion. And this can be called coaxing a motion. So board members also have an important role in contributing to a fair and orderly proceeding. In order to determine a project's conformance with your regulations and protect due process, board members should be listening to testimony and evidence, asking questions about the project as it relates to the regulations, referring to specific standards, being aware of any conflicts of interest that they might hold and disclosing those if they find that there might be one, basing decisions on evidence presented only, and ensuring that they're not prejudging a matter or publicly expressing opinions on a pending case. Deliberative session. So this is an exemption from the open meeting law. So this is not required to be noticed. The public is not required to be noticed. There's no requirement that minutes are taken. There's no requirement that the public be able to participate in a deliberative session. Some boards do choose to hold public deliberations following the public hearing, but this is not a requirement and we don't consider it to be a best practice. We think that is important for boards to take that 45 days to really carefully review the testimony and issue a well thought out decision. So boards do not have to reveal how board members voted. The decision is going to note a concurrence of majority of board members, and that final written decision is going to be part of the public record and be the decision. And again, 45 days. And if there is no action taken within that 45 days and a decision is not issued, then there is a process for deemed approval. Conflicts of interest can impact the fairness of a proceeding. It's important for board members to understand what constitutes a conflict of interest. And there are several different types. So you could have a financial interest, direct or indirect. So it could be that certainly if you were the property owner or a developer, that would be a direct financial interest. It could be indirect, where it could be that your brother owns the property. There could be a known bias or prejudice. Perhaps you hate all strip development and it's well known in the community, or you hate all tractor supply stores and it's well known in the community, or just used that as an example. So a known bias or prejudice that's well known in the community could create the appearance of a conflict of interest. And it's really the appearance that matters, because the point of managing conflicts of interest is to ensure that you're holding a proceeding that's orderly and that the public can have trust in. And then finally, ex parte communications, a little bit different than conflicts of interest, but these are direct or indirect communication between a member of the DRB and anyone else outside a public hearing on matters involving the application. So a DRB should not discuss a pending case with anyone at the supermarket or the post office when they run into someone who wants to talk about it. That can be difficult and it might happen. But if it does, it is important to disclose those communications at an open public hearing. The reason being is that all testimony and all information and all exchanges relating to the matters in the case everyone needs to have access to that same information in order for there to be a fair proceeding. So the correction, if there is some communication outside of the hearing, is to disclose it. Any questions on that? I guess now, finally, I'll just note the distinct difference between planning and regulatory functions in regards to communications. So members of a quasi-judicial board must restrict public communications to formal meetings and hearings. As I was just noting, we must not participate in ex parte communication, but a little bit different with planning commissions when they're working on it, like for example, a municipal plan update. When they're endeavoring to create strong lines of communication with the public on all planning initiatives beyond the confines of planning commission meetings and hearings. So just pointing that difference out, and the process the DRB must engage in when they're doing development review is much stricter. Managing conflicts of interest. So it's important to know and understand that conflicts of interest and ex parte communication happen. Right? Board members need to recognize them and have a process established for managing them. And this should be memorialized in the rules of procedure. So know where your rules of procedure are, have them available, refer to them in your public hearings. Asking for, at the beginning of the meeting, as I noted when I reviewed how the chair might open a meeting, asking for conflicts of interest and ex parte communication to be disclosed at the beginning of each meeting as a matter of just business that happens every meeting will allow for it to become common business and not such a big deal to have to disclose that. And then finally, taking it upon your responsibility on yourself to recuse yourself if necessary. because that is how one way of managing a conflict of interest is to recuse yourself. And that's why it's important to have alternates, so board member alternates, because as you might have members recusing themselves for conflicts of interest, you may need to bring in alternates so that you can have enough board members to conduct business. So in summary, conducting a fair proceeding that protects due process for all will set your town up for a solid land use decisions, less likely to be appealed, or at least the town will be less likely to lose an appeal. So in summary, these bullet points: proper public notice by posting the agenda and meeting notice. People are given the opportunity to be heard. Boards need to have structure for allowing the public to be heard, but it can be limited. It doesn't, you don't have to, you can structure a public comment period on your agenda. Ensure to conduct an orderly proceeding, which will help build trust in your development review process. A good chair, an established flow for opening and conducting hearings, and rules of procedure can help with that. Proper management of evidence. So boards need to listen to all testimony and make determinations of fact and apply it to the standards in the bylaw. And finally, proper management of conflicts of interest. Making it common business of your board to ask for disclosure so that it doesn't become such a big deal. Ensure that folks are disclosing any ex parte communications as well. So that is essentially the completion of our training tonight. We have some resources to note. The Essentials of Local Land Use Planning and Regulation is a booklet that's available that reviews a lot of the information that we covered tonight. And then there are also some templates that can be helpful. So plan and bylaw adoption tools and template rules of procedure and ethics manual. And this is all available at www.bpic.info. Are there any questions? Okay. These are some additional links and tools and resources available. And like we noted, the presentation will be available for review, we'll be posting it on the website where you can access it. And there will, I believe there will also be a recording available. Emily has posted a SurveyMonkey link in the comment, and we would greatly appreciate it if you would fill out that survey link for us. And
I have one question, Greta.
Yeah.
And I forget which screen I was looking at, but it had to do with taking minutes and noting who was attending the meeting. And there was the phrase active participant. What does active participant mean? They have to say something, or they're just there attending?
We're talking about meetings.
Meeting.
Okay.
And
We were talking about taking minutes. Okay.
yes.
So I guess this generally you want to have a description of the discussion of major discussion that happens at a meeting, but it doesn't need to be a transcript.
Right.
And so active participation is not like a legal term that's included in statute. This is really just a translation of a best practice to document what happened at a meeting to meet the intent of the open meeting law and providing access, to what happened at the meeting to the public.
So it's different from an attendance, like the sign-in sheet?
Different from the attendance. No, we're talking. So you need to have a list of everyone that attended the meeting.
Okay.
That's a requirement. But then in terms of documenting the discussions that happened.
Okay, I just wanted to clarify that. So got it.
Mm-hmm. Any other questions?
So I also have another question on and this was way back in the beginning, minimizing fragmentation of farmland. That was a goal of some sort.
Yeah, so we listed minimizing fragmentation of farmland as an example goal that might be in your town plan.
Okay,
And so then I talked about different ways that you could potentially create zoning standards that would.
it was an
further-
example goal. Okay,
Yeah, it was an example goal.
okay, thank you.
Greta, and I think it was you. There was a slide that showed the differentiation between the zoning administrator either moving forward on a review of a permit versus going directly to the DRB. Either way, I think it was kind of a flow chart kind of thing. What is the let me see if I can answer my own question. So the determination between which direction to go, would it be that the zoning administrator is looking if the application is conforming versus non-conforming? It would go to directly to the DRB and bypass the zoning administrator? I'm not clear about how that decision is made.
Right, so that decision is made by how that particular land use is categorized within your zoning regulations. And so typically there is a use table, we call it, where you list all of the land uses that are either allowed or disallowed in different zoning districts. So the uses are on the left-hand side, and then on the top of the table, typically we have the zoning districts. And then we fill in whether those uses are permitted, conditional, or conditional with site plan review, or I guess I left out permitted with site plan review. So if it's permitted without any conditional or site plan review required, that is a situation where there is only an administrative review required, or permitted use only requires administrative review. It is the conditional use and the site plan that requires the deliberative review from the DRB. So the zoning administrator is going to intake that application. They're going to look at, okay, well, what type of land use is this landowner wanting to conduct? They're going to find where that land use fits in with the existing use categories and figure out, okay, well, is it a permitted use? Or is there a site plan or conditional use required? If it's permitted, the ZA will just do that review. And there are going to be certain standards that are going to apply to only administrative review. And so they're going to confirm that, the setbacks are met, primarily height standards and those types of standards. And then they're going to issue that permit when they confirm that all standards are met. And then if there is a site plan or conditional use review, the zoning administrator is going to need to refer that application to the DRB, and the DRB is going to need to conduct a public hearing for potentially both of those reviews. When there is a site plan and a conditional use required, typically the DRB will hold what's called a joint hearing, where they're going to have one proceeding to consider both the site plan review and conditional use review standards. And then they're going to be issuing that decision, and the DRB will, once that decision is issued, will issue a final zoning permit.
Okay, good, thank you.
Okay, any other questions tonight? Okay, well, thanks everyone for coming out tonight. I hope this was helpful. If you want to look for any of look for the presentation afterward, or looking for any of the resources that were noted in the presentation, you can look for it online and find those. And also, just a reminder again, if you wouldn't mind completing that survey that is in the comments, that would be great. We would appreciate it.